Hello guys, Attorney Edward Littlejohn here for another edition of Ask Ed Live. That's right. We are live to go over the probate and estate planning question of the week. This week's question is about release of administration. We've had several callers call and ask, well, what is this release of administration? How does it work? When does it apply? What is it in comparison to full administration? Okay. So the first thing I want everyone to know is that in Ohio we have two processes which we can navigate through the probate court. The first is what we call a full administration. Now the way a full administration works is an estate gets opened up, someone gets appointed as an administrator, normally about 90 days after the appointment of the fiduciary, the estate being opened up, we have to appoint a fiduciary. And then about 90 days after that, so that puts us at about 6 months, you have to file an inventory and accounting or inventory and appraisal of the estate and the assets that the estate has. Then from there are some additional deadlines and kind of requirements, but the probate court kind of categorizes or catalogs all the bills, and then they decide which bills are going to get paid with the fiduciary's help. And then once they do that, you can get a court order to distribute the assets, and you file an inventory to say these are the assets that the fiduciary had in their possession, and these are the assets that had been distributed. Ultimately, the estate gets closed. Typically, that takes about 12 to 13 months. We do have some estates that have taken longer than that, typically because some third party or there's some litigation or something that's going on that may extend or prolong the process. So the release of administration is a streamlined process, okay? So that full administration, you're looking at a timeline of 9 to 12 months before the estate could be, closed. But for that release, it's almost instant. And I don't want to say that it is truly instant, but typically we open the estate on, say, a Monday, and by Monday a week later or maybe 2 weeks later, you'll have the estate closed. Now, in order to qualify for release of administration, it's very technical, okay? I mean, it is very technical. What I like to tell people are the two main kind of groups or classifications that we have are the surviving spouse being the first, and the assets have to be less than $100,000. So if all the assets are going to the surviving spouse and it's less than $100,000, then the estate qualifies for a release of administration. The other option would be if the estate is $35,000 or less. Now, if it's $35,000 or less, and it doesn't matter that it's not the surviving spouse, it could go to the children, it could go to any next of kin, but $35,000 or less, then it could qualify for a release of administration. Those are the two primary kind of situations where we use release of administrations. Another one that does get used or employed is when there's real estate only. It could qualify for a release of administration. If you have real estate only, give us a call. We'll set you up for a needs assessment so that you can determine if it's in your best interest or if we even qualify for the release of administration. Now, the thing with the release of administration, this is why it's kind of a drawback, but it is good, okay? But there is some drawbacks to it. When you do a release of administration, you're essentially telling the probate court that your loved one who's passed away only had this, and this asset. So maybe a small amount of assets. You know exactly how much those assets are worth, and you're asking the probate court to transfer them to the next of kin, period, okay? The probate court's not going to get involved with the inventory in a release of administration. They're not going to get involved in the accounting in a release of administration, and they're not going to get involved in creditor claims in a release of administration, okay? What they're going to do is they're going to review the itemized list of the assets, and then you'll get a court order to transfer those. Now, one issue that we often see when it comes to release of administrations are you have to be very specific. So if my loved one had a bank account and that bank account had, say, $5,494 in it. The documents have to say $5,494. Most banks will reject a court order that says transfer a different amount to the specific person because the amounts aren't right. And in those scenarios, you have to go back to the probate court, ask them to reissue the documents. And so the release of administration doesn't include what I like to call the magic key. Okay? When you get a full administration, you get the magic key to be able to go and open up any bank account, any IRA, life insurance policy, basically any asset that had your deceased loved one's name on it. You have a magic key to gain access to it. With the release, you don't get the magic key. It's just a court order to transfer. If you're not sure which one of your family qualifies, give us a call, 740-346-2899. And remember, where there's a will, there's a way. And where there's no will, then there's probate.